Good afternoon. My name is Mike McCoy, and I am the director of Mountain States Legal Foundation Center to Keep and Bear Arms. A little while ago, the Supreme Court heard oral arguments in the case of Garland v. VanDerStok, a pivotal case challenging the Department of Justice and ATF's efforts to bring privately made firearms under regulatory control of the executive branch. Mountain States Legal Foundation first brought this case in 2022 after the ATF issued a new regulation that reinterpreted and expanded its own authority and for the first time in the history of this country unlawfully imposed commercial firearms regulations on American individuals who just wanted to make their own firearms. The problem for the ATF, and the reason why the case is in front of the Supreme Court today, is because Congress never gave the ATF the power to regulate privately made firearms. And in fact, it repeatedly refused to give such authorization. And a basic understanding of American history and tradition indicates why. For centuries, Americans have exercised their right to make their own firearms. Homemade firearms ushered us through the difficult colonial era and helped us secure victory over tyranny during our American Revolution. To this day, privately made firearms continue to be a critical component of Americans' constitutionally protected right to keep and bear arms. So why then did the ATF decide to take this overreaching approach? Well, because the Biden-Harris administration has made it plainly clear that they desperately want to control all means and methods of firearms production and possession in this country. But they cannot control that which Congress has not given them authority to regulate. Congress, the branch of our government that is composed of elected representatives and not unelected bureaucrats. Our founding fathers had the good sense to enshrine the separation of powers in our Constitution for this very reason. But by pushing forward with the 2022 regulation, the Biden-Harris administration decided to ignore Congress and act on their own. The separation of powers and the Constitution be damned. Now, on the surface, Garland v. VanDerStok might appear to be just another administrative law case about the extent of an executive branch agency's authority to interpret the law. But it is actually much more than that. In reality, the VanDerStok case is the latest battle against the Biden-Harris administration's unceasing efforts to have executive agencies, which are not Congress, legislate away the natural and constitutionally protected rights of all Americans. Well, that cannot stand. Mountain States and all of our partners in this case refuse to let that stand. The separation of powers is a fundamental part of our democracy, and the ATF's attempt to regulate homemade firearms is a clear violation of that principle. We are grateful and honored to have had this case appear in front of the Supreme Court, and we look forward to the court's decision. Mountain States would like to thank our partners in this case, especially Cooper and Kirk and Firearms Policy Coalition, for fighting alongside us in defense of the Constitution, the separation of powers, and of course, liberty. We also want to particularly highlight and thank our individual plaintiffs, Jennifer VanDerStok and Michael Andren, two individuals who had the courage to stand up and push back, not just for the sake of their own rights, but for the rights of all their fellow Americans as well. Thank you.